Dear students, viewers and the subscribers, welcome to the IAS Mentor. We are in lecture number 8 in the series Indian Polity, and our objective of this particular series is to provide a comprehensive idea about the Indian Constitution and also to cover important books related to the subject Indian Polity, which will majorly focus upon books like LAXMIKANTH, D.D BASU, which are all relevant for UPSC IAS examination. This series is not only relevant for the students preparing for UPSC IAS examination, but also for any other competitive examination, including the various public service, state public service examination. So with that, we'll move to the lecture number 8, where we are going to see an important topic today, that is the salient features of the Indian Constitution. We know that the Indian Constitution is one of the lengthiest written constitution in the world. Not only it is a lengthiest written constitution in the world, but it also has many important features as a part of this constitution. And in fact, we also know that one of the feature of the Indian constitution is also it is a borrowed constitution, which means the Indian constitution has been borrowed from multiple sources. So along with those things, let us try to understand some of the important features of the Indian Constitution in today's lecture, which in my opinion is a very, very important lecture. It's a basic lecture, but it's a very, very important lecture because from the examination point of view, every year there's 1 or 2 questions just from the salient features. So it's very important for your examination. So before I get into the lecture, what we have covered till this point of time. So we understood as to what is a constitution. We have seen as to what is the background behind the establishment of Constituent Assembly, based on which the Constituent Assembly was established and how the Indian Constitution was drafted by the Constituent Assembly. And then we also seen the historical background, basically when the Britishers ruled India as a part of the company rule as well as the crown rule. And that's also one area where probably question can come, especially in UPSC examination. You can expect one question, and in state PCS examination also you can expect probably few questions from those areas. But now let us enter into the conceptual part of the constitution, that is the salient features of the constitution. Sorry. And the first and foremost thing that I wanted to discuss as a part of the salient features of the constitution is that the concept of what is called as democracy. That means the Constitution of India says that it is a democracy. So we'll have to broadly understand as to what does it mean by democracy. We have already learned that Constitution is nothing but a rule book, and it is a rule book based on which the country is to be governed. And our Constitution says India is a democracy, which means the idea of democracy is reflected in number of areas in the Constitution. Take the example of the preamble. The preamble says, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. And this word democratic or democracy is reflected in number of other provisions as well. So fundamentally, we should have an understanding of what does it mean by democracy. So to put it in a very simple way, democracy means rule by people, or any government that would rule the country or any government that is formed in India will have legitimacy only when it has the support of the people. So ultimately it is the people who can elect their rulers, and that's basically what is called as the idea of democracy. And for democracy to thrive, there are certain important features, and those features are also implied in the Constitution of India. Now remember, not every constitution in the world is a democratic constitution. But today in the modern world, most of the constitutions are democratic in nature. And India is considered to be one of the most liberal democracies today in the world. So when I say democracy, democracy means rule by people, which means any government in India can be only elected by the people. And ultimately it is the people who will elect their rulers. And that's basically what is called as democracy. That's why we say democracy is nothing but rule by people. It's a government for the people, of the people, and by the people. So ultimately, the power of authority is the people of India, and it is the people of India who is going to elect their government. And for democracy to thrive, there are certain other features which you'll have to keep in your mind. So first and foremost, when you talk of democracy, that all the people in India should have the right to vote. If, say for example, during the Government of India Act 1919 and the Government of India Act 1935, we have seen that there was a direct election, but there was no universal adult suffrage. There was only limited adult suffrage. Only limited individuals in our country was given the right to vote. That does not go well with the idea of what is called as a liberal democracy or a democracy. So democracy means everybody shall have the right to vote, or every eligible individual shall have the right to vote. And that's why the constitution provides for what is called as universal adult suffrage. So if you take any democracy as a matter, that it should have what is called as universal adult suffrage. That means all the eligible individuals shall have the right to vote. And if you see in the Constitution of India, all the adult individuals in our country are given the right to vote without any discrimination on various grounds. So one of the essential feature of democracy is universal adult suffrage. Everybody is given the right to vote. Okay, everybody is given the right to vote. Is that sufficient enough to be a democracy? Apart from that, to consider it to be a democracy, it should also have what is called as free and fair election. That is also very, very important. Okay, even before going to free and fair election, that there should be what is called as periodic election. That is also an essential feature of democracy. What does it mean by periodic election? That at a regular interval, election shall be held. And in the elections, people will vote. And in fact, all the adult individuals will vote. And then they elect their representatives. And their representatives will form the government. And that is how the democracy in India is established. So, first of all, there should be universal adult suffrage, that all eligible individuals shall have the right to vote. Second is that there should be periodic election. Do we have periodic election under the constitution? Yes. And in fact, you might understand that the election to the parliament and the election to the state legislature, in fact, happens every 5 years. Sometimes even before that also. So depending upon certain circumstances and situations, which we'll try to understand. Otherwise, normally election happens every 5 years. So we have universal adult suffrage, we have periodic elections, and most importantly, in order to qualify as a democracy, those elections should also be a free and fair elections. If the elections are not free and fair elections, then it would be a mockery of democracy. What do you mean by free and fair elections? Free election means it should be free from any form of malpractice. And fair election means that everybody should have a fair opportunity and chance in contesting and winning the election. So the constitution also provides for free and fair election, and that is why to conduct elections in India, there is an independent body which is established under the constitution itself, and that is nothing but the Election Commission of India. So if you look into Article 324 of the Constitution, you don't have to worry about the articles at this stage. We'll discuss and we'll see all those things at the later stages. But Article 324 in the Constitution allows for an independent election commission, and that election commission responsibility is to ensure what is called as free and fair election. So if you talk of democracy, what is democracy? So democracy means it is the rule by people or any government that would have legitimacy only if it has a support of the people, or only if it is elected by the people. And to qualify as a democracy, there should be other supporting features as well. And what are they? First, it should provide for what is called as universal adult suffrage. There should be periodic elections, and it should be free and fair elections. So do we have all these things as a part of the Indian Constitution? Yes, we do have all these things as a part of Indian Constitution. That's why we say that India is a democracy. Now, India is not merely a democracy, but India is also what is called as a parliamentary democracy. So what do you understand by parliamentary democracy? In fact, if you see democracies across the world, today the democracies across the world is basically classified majorly into two types. Either it is a presidential democracy or it is a parliamentary democracy. Whereas in case of India, we are a parliamentary democracy. Say, take the example of United States of America. That's a presidential democracy. They are also democracy. There also there is universal adult suffrage. There also there is free and fair election. There also there is an independent body which will conduct the election. But in India, it's a parliamentary democracy, and in USA, it's a presidential democracy. So basically, what is a parliamentary democracy? Now, parliamentary democracy, in other words, it is also what is called as an indirect democracy. Mostly it is an indirect democracy. So what do you mean by indirect democracy? I said democracy means rule by people, but in the modern context, if you see, the people do not directly rule. And say, take the example of India. India is such a huge country, and if the people have to directly govern India, it becomes extremely difficult. It's a very complex process. The population is so high, and the people to come and arrive at a decision becomes very difficult. So what normally happens in most of the modern democracies is people elect their representatives, and once they elect their representatives, people delegate this power to their representatives, and the representatives rule the country. And that's basically an idea of what is called as indirect democracy. So indirect democracy means not people directly rule, but people elect their representatives, and those representatives rule the country. So now coming to the concept of what is called as parliamentary democracy. So why India is called as a parliamentary democracy? India is called as a parliamentary democracy because of the fact, now in India there is an indirect democracy, which means people elect their representatives, which we call as, say example, the members of parliament. You know that every 5 years, sometimes even before 5 years, under certain circumstances under the constitution, which we'll understand later, but for the easy understanding right now, let us assume that every 5 years the election to the Lok Sabha happens. And recently in 2024, mid 2024, the elections to the Lok Sabha has happened. If you know the answer, you can put it in the comment box. So that is how many times the elections to the Lok Sabha has happened till this point of time. The election that happened in 2024 is the latest Lok Sabha elections. So let me also give an option to that. Is it 16th Lok Sabha elections, 17th Lok Sabha elections, 18th Lok Sabha elections, or 19th Lok Sabha elections? One among this is the answer. You can put your answer in the comment box. Anyways, now the election to the Lok Sabha has happened, and people elect their MPs to the Lok Sabha. So these MPs are nothing but the representatives of the people, and these MPs are elected from the different constituencies in India, and then they go to the Lok Sabha, and from the Lok Sabha somebody will form the government. Say for example, today the NDA coalition is in government, the National Democratic Alliance is in government. So that means once people elect their representatives, they go to the Lok Sabha, and today in the Lok Sabha there are 543 members. So we'll discuss about all these things at the later stages. And for someone to form the government, out of these 543 members, they need to have a majority. And what is the majority that is required for anyone to form the government? Be it a single party or be it a coalition of party, they need to have a majority of 543, which would roughly, or which would exactly is 272 seats. So any political party or a coalition of political parties, it may be a coalition also. It can be a pre-poll coalition or it can be a post-poll coalition, that doesn't matter. But to form a government, a single party should have this majority. If single party is not having the majority, it should be coalition of parties. And if they have the majority, then that coalition or the individual party can stake claim to form the government. So that individual party or the coalition of party, they would approach the President of India and they would say that we have the requisite majority to form the government. And then accordingly, the President will appoint the leader of that particular party as the Prime Minister. So for example, today Mr. Narendra Modi is the Prime Minister of India, and he is the leader of the National Democratic Alliance, that coalition, and hence he is appointed as a Prime Minister. And then he will recommend the names of the other ministers, and those people will be appointed as the ministers. So this is normally how it happens, or how the government is formed in a parliamentary democracy. Now coming to the understanding of what is a parliamentary democracy. So further if you see. So what happens in a parliamentary democracy? Parliamentary democracy is also an example of indirect democracy. That means people elect their representatives, and those representatives, where they go to the parliament, to be very specific here in Lok Sabha. And in the Lok Sabha, whoever is having the majority, they form the government. So from where the government is actually formed? The government is actually formed from Lok Sabha, which is part of the parliament, and that is also the reason it is why it is called as parliamentary democracy. But the story is not over here as to why it is a parliamentary democracy. First thing, we have understood that the government is formed from where? From the parliament. That is, to be very specific, in the Lok Sabha. Now, once the government is formed, it is not that the government can continue for the next 5 years. So, normally any government which is formed, it continues for 5 years because the term of the Lok Sabha is 5 years. So, as long as the term of the Lok Sabha is there, the government is likely to continue. This is the basic understanding. But in a parliamentary democracy, it is essential that you should understand any government that is formed from the parliament, that is Lok Sabha, which is a constituent part of the parliament, any government which is formed from here, because they had the majority, as I already said, that 272 members, is not only that they should have that majority at the time of forming the government, and as long as they continue in the government, they need to have this majority in the Lok Sabha. At any point of time, if they lose the majority in the Lok Sabha, that government which is formed, if they have less than 272 members in the Lok Sabha who support them, then this government will be dismissed by the President of India. So, or in other words, what is a parliamentary democracy? A parliamentary democracy is something which is continuously accountable to the parliament. And how the government is continuously accountable to the parliament in a parliamentary democracy is because of the fact the government needs to have a majority in the parliament always. To be very specific, in the Lok Sabha, they should always have this minimum 272 members or MPs supporting this particular government. It can be more than that, but it should not be less than this. So, this is basically why it is called as parliamentary democracy. Or in other words, to put it in a very simple way, a parliamentary democracy is something where the government is always accountable to the parliament, to be very specific, to the Lok Sabha. Or in other words, the legitimacy of the government comes only if it has the majority in the Lok Sabha, which is part of the parliament. And that is why it is called as parliamentary democracy. In fact, in the Constituent Assembly, there was a debate as to why India should go for a parliamentary democracy. Because some of the members in the Constituent Assembly was saying that India should become a presidential democracy. While there is no doubt or there is no conflict as to what type of democracy India has to be, but there was some element of confusion between India be a parliamentary democracy or a presidential democracy. And then finally, they accepted on the concept of what is called as the parliamentary democracy, because a parliamentary democracy is more accountable than the presidential democracy. And how the parliamentary democracy is more accountable than the presidential democracy? Because in the parliamentary democracy, they should always have the majority in the Lok Sabha. And the moment the government is not having the majority in the Lok Sabha, this government will be dismissed. Or in other words, if the government functions arbitrarily, then there is a possibility that the MPs might withdraw the support and thereby ensuring the accountability of the government. So, the Constituent Assembly has preferred accountability than anything else. So, they have decided in favor of what is called as the parliamentary democracy. So, now come to the next feature of Indian Constitution, that is separation of powers. So, I am quite clear that you have proper understanding as to what is a democracy, what is a parliamentary democracy. So, now we will go to the next concept, that is separation of powers, and again that is a very important feature in the Indian Constitution. Now, what do you understand by separation of powers? There is a saying which was said by Lord Acton, which is called as power corrupts and absolute power corrupts absolutely, which means if you give authority to a particular person, power to a particular person, then there is a possibility that he can arbitrarily exercise that particular power. And most importantly, if you give absolute power without any checks and balances to that particular individual, it might be possible that he can become even more arbitrary. Now, this thought was taken by the Constituent Assembly, and they thought that in any constitution, all the functions should not be entrusted in one particular authority. And if all the functions are entrusted in one particular authority, there is a possibility that this power may be misused. And hence, what the Constituent Assembly has thought is that they will create different power centers within the Constitution. And who are these different power centers within the Constitution? One power center is the legislature, one power center is the executive, and probably another power center is what is called as a judiciary. So, we have three different authorities broadly. One is the legislature, other is the executive, and the third thing is what is called as the judiciary. What is this legislative body supposed to do? The legislative body is supposed to make laws. And what is this executive body supposed to do? The executive body is supposed to implement these laws. And what is the judicial body is supposed to do? The judiciary is supposed to review the actions that is done by the legislature as well as the executive. When I say that they are supposed to review the actions that is done by the legislature and executive, that means whatever is a law made by the parliament, that is the legislative body, or whatever is the executive action that is done by the executives, if they are in violation of the constitution, then such actions can be struck down. And who can strike down those actions? It is the judiciary which can strike down those actions. So this is basically what is called as the separation of powers, having three different authorities. And because these three different authorities means the power is not concentrated in one single authority, and thereby you can bring in certain element of what is called as checks and balances as well. But before we proceed further, we should understand, although the constitution provides for what is called as separation of powers, there is no clear separation of powers under the constitution. When I say clear separation of powers, are these organs separate from one another? Of course, judiciary is completely separate from the executive and the legislature. But whereas on the other hand, there is some element of overlap between the legislature and the executive. So before I proceed, you should also have an understanding of what these bodies are actually. When I say legislature means, say for example, it is the parliament and the state legislature. They are all considered to be legislative bodies. Executive means the political executives. The Union Council of Ministers, that is the Prime Minister and the Council of Ministers at the union level, the Chief Minister and his Council of Ministers at the state level, they are all considered to be executives. And then you have a judiciary. What is this judiciary? Judiciary is the hierarchy of courts that we have in India. At the lowest level, we have the subordinate courts, and the highest level, we have got the Supreme Court, the apex court, and then in between the subordinate court and the Supreme Court, we have got what is called as a high courts. So this is what is called as a judiciary. So now the question is there clear separation of powers between all the three organs? Although the constitution recognizes the principle of separation of powers, but we should also accept and understand that in the Indian constitution, that there is no clear separation of powers. While the judiciary is separate, no issues, but there is some element of overlap between the legislature and the executive. Why there is some element of overlap or between the legislature and the executive? Because I said from where the government is formed. The government is formed from the legislature. So for example, the Union Council of Ministers and the Prime Ministers come from the Parliament, and the State Council of Ministers and the Chief Minister come from the state legislature. That means, say for example, Mr. Narendra Modi, who is the Prime Minister of India, he is part of the executives, but he is also a member of Parliament in the Lok Sabha. So he is also part of the legislature, and he is also the executive, he is also the Prime Minister. Same is true with, say let us assume the Home Minister of India, Mr. Amit Shah. He is also part of the legislature, that is the Lok Sabha, he is also part of the executive. So there is some element of overlap between the legislature and the executive. So to say that there is a clear separation of powers in India, that is not true. But yes, we do recognize the principle of what is called as separation of powers. But however, the constitution beyond that also provides for a system of what is called as checks and balances. So what is this checks and balances? The Constitution of India relies more on the principle of what is called as checks and balances. I am repeating it again. So what do you understand by checks and balances? So checks and balances means that one organ will have some element of control over the other organ. Say for example, the judiciary can review the actions of the legislature and the executive. And if the legislature is making a law which is violative of the constitution, that can be struck down by the judiciary. If the executives are taking any action that is violative of the constitution, that can also be struck down by the judiciary by using its power of judicial review. Similarly, the judges in India can be removed by the parliament. Parliament, of course, based on a motion that is passed by the parliament and then approved by the president. So there is some element of control over the judiciary by the legislature and the executive, whereas on the other hand, the judiciary is having some element of control over the legislature and the executive. And similarly, the executives are controlled by the legislature, because the Prime Minister and the Council of Ministers always need to have a majority in the legislature, that is in the Lok Sabha. So in this way, there is some element of control which is there by one body over the other body, and there is a system of what is called as checks and balances, and that is also a very important feature of the Indian Constitution. So while we do recognize the principle of separation of powers, but again it is very important, we do not have clear separation of powers, but what we also have what is called as, although there is no clear separation of powers, we do have a system of what is called as checks and balances. Come to the next thing, that is division of powers. What do you understand by division of powers? Now, division of power is something where the Constitution divides the power. So who is dividing the power? The Constitution itself is dividing the power. And the Constitution itself is dividing the power between the national government and the subnational government, or the national authority and the subnational authority. So for example, the Constitution itself is demarcating and clearly saying as to what is the power of the union executives and what is the power of the state executives. Or in other words, what is the power of the Prime Minister and the Council of Ministers at the union level, and what is the power of the Chief Minister and the Council of Ministers at the state level. What is the power of the union legislature, that is the parliament, and what is the power of the state legislature. What are the areas on which the parliament can make laws, or what are the subject matters on which the parliament can make laws, what are the subject matter on which the state legislature can make laws. Now all these things are mentioned where? All these things are mentioned clearly in the Constitution itself. And the Constitution is the source of power for both the center as well as the states. Neither the center can encroach upon the powers of the state, nor the states can encroach upon the powers of the center. That also you should understand, that the state governments in India are not subordinated to the central government, but rather they both derive their powers from the Constitution. And wherever there is a clear division of powers which is provided in the Constitution, we also call such a constitution as what is called as a federal political system. You might have heard of the word federal. So federal means where there is a division of powers. And who is dividing this power? The Constitution itself. The Constitution gives directly the power to the center. The Constitution directly gives the power to the state executives. The Constitution directly gives the power to the union legislature. The Constitution directly gives the power to the state legislature. For example, if you go to the Schedule 7 in the Constitution, we have already learned that there are 12 schedules in the Constitution. Original Constitution had 8 schedules, but today we have got 12 schedules. And in that, if you go to the 7th schedule in the Constitution, it talks about something which is called as union list, something which is called as a state list, something which is called as a concurrent list. Now, whatever is there in the union list, that is the subject matters, the items in the union list, it is only the power of the parliament to make laws. And whatever item which is there in the state list, it is normally the power of the state legislature to make laws. So how do we know all these things? We know all these things because that is what the Constitution says. And this is how the Constitution demarcates the power. And that's basically what you'll have to understand. And that's basically what is called as a system of division of powers. Is that clear to all of you? So we understood as to what is democracy. We understood what is parliamentary democracy. And in a parliamentary democracy, the government that is formed is accountable to the parliament. And once the government is formed, the people cannot remove them. It is only the elected representatives, they have the power to remove them even before the completion of the term. And that is also what it is called as no confidence motion. I'm sure that you might have heard of this no confidence motion. So any government that is formed, but if there is a no confidence motion that is passed against the government in the parliament, to be very specific in the Lok Sabha, then the government can be removed even before the expiry of the term. So basically any government is accountable to the parliament. So that's why it is parliamentary democracy. Separation of powers, different authorities under the Constitution perform different function, and thereby there is an element of checks and balances as well. Although we do not have a clear separation of powers, because there's an element of overlap between the legislature and the executive, but we do have a system of what is called as checks and balances. Division of powers. The constitution demarcates the authority between the center and the states. Central executive, central legislature, state legislature, what they are supposed to do. And one cannot encroach upon the powers of the other because the constitution is directly giving them the powers, the respective powers, and they can exercise and enjoy their respective powers. Okay, so this is division of powers. And then the next salient feature is federal system with unitary bias. So what do you understand by federal system with unitary bias? When I say federal system with unitary bias, we already understood that all constitution which provides for division of powers, then they can be considered to be what is called as a federal constitution, no doubt. But when I say it's a federal constitution with unitary bias, so this is something that you have to understand. A federal constitution with unitary bias is something, although there is division of powers, who is given more powers under the constitution is the union government, is the union legislature vis-a-vis the state government or the state legislature. And that's why we say that it is a federation with unitary bias or a federal political system with unitary bias. Federal political system means there is a division of powers. But is there equal division of powers? No, there is no equal division of powers. So somebody is given more powers, somebody is given less powers. And who is given more powers? It is the union executives. It is the union legislature. So in this case, it is nothing but the union executive and the parliament which is given more powers. There are a number of provisions in the Constitution of India which does give more powers to the union executives and the union legislature, which we'll subsequently understand. But right now try to understand that although the Constitution of India is a federal constitution, that means there is division of powers. Is there an equal division of powers between the center and the state? No. More powers has been given to the center. Does it mean that the states are subordinate to the center? No, that is also not the case. They derive the powers directly from the constitution, and whatever they derive from the constitution, to that limit they can exercise their powers. So this is basically what you'll have to understand. There are a number of examples under the constitution we can say as to why it is called as a federation with unitary bias. Say for example, Article 3 of the constitution is one classic example which we will subsequently discuss, that where it is authority of the parliament to unilaterally create new states in India. Say for example, initially we did not have 28 states, today we have 28 states, and tomorrow we may have even more, or even we may have less than this. And who is authority to decide all those things? It is the parliament. Even a state cannot stop this. Say for example, when Telangana was created from Andhra Pradesh, because earlier it was one single state Andhra Pradesh, but now Andhra Pradesh is divided into Andhra Pradesh and Telangana. When this proposal was brought in, the state legislature of Andhra Pradesh was not in favor of this. But however, despite this, the parliament has went ahead and created a separate state of Telangana. And so this power is an unilateral power of the parliament. That's why we say that though we are a federation, we are not a federation with equal powers, a federation with unitary bias, which is giving more power to the union executive and more power to the union legislature in relation or in comparison to the state executive and the state legislature. And then the next thing is integrated and independent judiciary. Very, very important thing. So what do you understand by integrated and independent judiciary? Let me first talk about what is an independent judiciary. So what is an independent judiciary? An independent judiciary is something which is independent of the other two organs of the state. That means, can the judiciary be controlled by the executives? No. Can the judiciary be controlled by the legislature? No. Not in their day-to-day functioning. There is some element of checks and balances. I am not denying that. But what kind of judgment is to be given by the judges? Can the other organs of the state control that? Definitely they have no power over that. So that's basically what you'll have to understand. So it's an independent judiciary, and this independent judiciary is must in order to protect the constitution. Because ultimately it is the Supreme Court of India which is the protector of the Constitution of India. And to ensure this particular duty, The Supreme Court, rather, the judiciary itself should be independent. That means they should be free from the other two organs of the state. Or in other words, the legislature and the executive should not impose any of their will upon the judiciary, and otherwise there would not be justice that can be administered in India, and that's the reason the constitution provides for independent judiciary. And how this independence is ensured to the judiciary? This independence is ensured to the judiciary through number of ways. In fact, one is removal of judges is not easy. In fact, removal of judges is extremely difficult in India. And in fact, not even a single judge of the Supreme Court or the High Court has been removed in our country till this point of time. Although that can be done by the legislature and the executive, it has not happened. And they have made the process so difficult is to ensure what is called as the independence of judiciary. So in this way, there are a number of provisions in the constitution which does provide independence to the judges in our country. That is basically what is called as independent judiciary. But we shall also understand as to what is an integrated judiciary. So what is an integrated judiciary? We have not only an independent judiciary which is free from the other two organs of the state, but we also have something which is called as an integrated judiciary, which means we have one single hierarchy of judiciary, and that's basically what is called as an integrated judiciary. I'm just repeating it again. We have just one single hierarchy of judiciary. We do not have parallel judiciaries. That means we do not have one hierarchy of judiciary for the states and one hierarchy of judiciary for the center. No, we have only one single hierarchy of judiciary for both the center as well as the state. For both the center and the state, there is only one Supreme Court. For both the center and the states, there are high courts in every state. And then there are subordinate courts. In other words, you should also understand that all the courts in our country, they can look into both the central as well as the state laws. It is not that we have a separate hierarchy of courts for the central laws, and it is not that we have a separate hierarchy of courts for the state laws. There are some countries which have a separate hierarchy. Say for example, in United States of America, there is a separate hierarchy of courts for the state laws and there is a separate hierarchy of courts for the central laws. But that is not the case in India. A central law can also be challenged in any court. A state law can also be challenged in any court. So this is basically what you'll have to understand when I say that we have one single hierarchy of judiciary. So we do have what is called as independent and integrated judiciary. Is that clear to all of you? All right. So now we'll move to the next feature is it is drawn from multiple sources. That is again very important. We already know this. And in fact, one of the way to describe the Constitution of India is the Constitution of India has been drawn from multiple sources. It is also called as a borrowed constitution. That is true. Because when India or the Constituent Assembly of India was drafting its constitution, there are various countries across the world who have already had their own constitution. And hence, the Constituent Assembly took some of the important provisions from different constitutions of the world. And say for example, we have taken the idea of fundamental rights from the Bill of Rights of the American Constitution. We have taken the idea of parliamentary democracy from the British parliamentary democracy who ruled India over 200 years. We have taken the idea of justice, liberty, equality from the Constitution of France. We have taken the ideas of fundamental duties from the Constitution of USSR. We have taken the idea of directive principles of state policy from the Constitution of fundamental duties from the Constitution of Ireland. Sorry, directive principles of state policy from the Constitution of Ireland. We have taken a lot of other ideas. Say for example, we have taken the idea of concurrent list from the Constitution of Australia. We have taken the idea of a federal political system with unitary bias from the Constitution of Canada. And in fact, we have also taken a number of provisions from the Government of India Act 1935 also, based on which we are governed before the commencement of the Constitution. So basically, that is why the Constitution of India is also what is called as a borrowed constitution. Okay, so you can just remember some of the things that I have told, but it is not very important that can be asked in the examination, but you should have this idea that the Constitution of India is a borrowed constitution. And we have taken the powers of judicial independence and judicial review from the Constitution of USA, and so on and so forth. There are a number of provisions that has been borrowed from different constitutions. The kind of emergency provisions that we have in India is much similar to that of what is there in the Constitution of Germany. So these are all some examples to say that the Constitution of India is a borrowed constitution. And then we do have what is called as fundamental rights. That's again one of the important salient feature of the Indian Constitution. Now, what do you understand by fundamental rights? Now, fundamental rights are those rights which is guaranteed in part 3 of the Constitution. So, if you go to the Constitution, there is a separate part which is called as part 3. And in fact, in part 3 today, there are 6 themes of fundamental rights. We have right to equality, right to freedom, we have right against exploitation, we have right to freedom of religion, we have cultural and educational rights of minorities, and the 6th one is we have the right to constitutional remedies. These are the 6 themes of fundamental rights which is today there in part 3 of the Constitution. In fact, in the original Constitution, there was also one more theme of fundamental right, that is right to property. But the right to property has been today done away with. It has been taken out of part 3 of the Constitution by the 44th Constitutional Amendment Act 1978. So, today we have these 6 themes of fundamental rights. I am not saying 6 fundamental rights, 6 themes of fundamental rights, and within every theme there are a lot of other fundamental rights. These 6 themes are fundamental rights, and whatever is mentioned in part 3 of the Constitution, only they are considered to be fundamental rights. Any right which is outside part 3 of the Constitution, it may be in the Constitution also, or may be in the ordinary laws of the land. Some of the ordinary laws which is passed may confer some rights. Now, they are all not considered to be fundamental rights. Now, what is fundamental right? It is whatever is within the part 3 of the Constitution. Say for example, right to equality, that is equality before law or equal protection of law, Article 14 is a fundamental right. Right to freedom of speech and expression, right to freedom of religion. Say for example, right to education under Article 21A, right to life and liberty under Article 21. So, these are all which is mentioned in part 3 of the Constitution. Right from Article 12 to Article 35 in the Constitution, only they constitute what is called as a fundamental rights. Apart from that, all other rights, although they may confer you some right, but they are not fundamental rights. They may be legal rights, they may be constitutional rights, but they are not what is called as fundamental rights. Again, I am repeating it, whatever is there in part 3 is what is called as fundamental rights. So, now why certain rights are there in part 3 of the Constitution and they are titled as fundamental rights? Because in the opinion of the Constituent Assembly, these rights were more important than any of the other rights. These rights are very essential for the dignified human survival of an individual. These rights are more important for the development of an individual. These rights are important to restrict the arbitrary authority of the state. And for all these reasons, the Constituent Assembly thought that you need to give some priority to certain rights over the other rights. And those rights which will get the priority or which will be given more importance are put under part 3 of the Constitution, and that's basically what is called as the fundamental rights. And in fact, the fundamental rights, as I already said, there are 2 important objectives. One is to limit the authority of the state so that the state cannot function arbitrarily. Say for example, if you look into Article 21 of the Constitution, it talks about right to life and liberty, which means it prevents any arbitrary action by the state in depriving the right to life and liberty of an individual. The Constitution also provides for protection from arbitrary arrest. So, the citizens or the individuals in our country cannot be arbitrarily arrested by the police because it's their fundamental right not to get arrested arbitrarily. Say for example, the Constitution under Article 15 talks about no discrimination by the state on the grounds of religion, race, caste, sex or place of birth. So, the state in its policy cannot discriminate between its citizens. So, that means the fundamental rights are aimed at protecting the arbitrary action of the state. Say for example, the arbitrary policies and the arbitrary laws of the government. So, the fundamental right does put restriction upon the powers of the state. So that is one aspect of the fundamental rights. But apart from that, the fundamental rights also enables a citizen to develop themselves. Say for example, right to education is there. So thereby, by getting the education, the citizens can develop themselves. So if you see the fundamental rights, they are both protective in nature as well as promotive in nature. But the major idea is to restrict arbitrary action of the state. So this is basically what you'll have to understand as to what is a fundamental right. I'm just repeating it again. These are all the rights which are placed in part 3 of the Constitution, from Article 12 to Article 35, basically to restrict the arbitrary powers of the state. Today we have got 6 themes of fundamental rights. Okay, right to property is no longer a fundamental right, although it remains in the Constitution, but not in the part 3 of the Constitution. It was taken out by the 44th Constitutional Amendment Act in 1978. So this is a basic idea that I wanted to give. But when I get into fundamental rights, I will discuss more in detail about the fundamental rights. Come to the next thing, that is fundamental duties. That is again one of the important feature in the Indian Constitution, which, as we have seen, that we have taken this idea from the Constitution of USSR. In fact, these fundamental duties were not part of the original Constitution. It was inserted by the 42nd Constitutional Amendment Act in 1976, based on the recommendation of Swaran Singh Committee, a committee which recommended that we shall provide some fundamental duties, which is basically a set of moral obligation upon the citizens to perform this duty towards the state. The word moral obligation is of important significance. Now, why the word moral significance is very important? Today you might understand this fundamental duties are there in part 4A of the Constitution. And if you go to part 4A of the Constitution, today there are 11 duties that is mentioned. Say for example, right to respect the duty to respect the national anthem, national flag and all those things. Duty to protect the environment, duty to protect the nation. So these are all some of the duties that is mentioned in the fundamental duties. But when I say moral obligation, that these duties are not legally enforceable. That means if as a citizen, if we fail to perform these duties, can the government or the state take action against us? It is not possible, because it is only an obligation on our side. It is an obligation on our side, but it is only a moral obligation. On the contrary, you see the fundamental rights. The fundamental rights are legally enforceable. That means if any of the right is violated, then we can directly approach the Supreme Court of India under Article 32. Not only we can approach the Supreme Court of India under Article 32, we can also approach the High Courts under Article 226, and we can seek appropriate remedy for the violation of the fundamental rights. While the fundamental rights are legal obligations for the state not to take away the rights of the citizens, whereas the fundamental duties are only the moral obligation upon the citizens towards the state. So if they do, it's all right. If they do not do, no action can be taken against them. So that's basically what you'll have to understand. And then there is something which is called as the directive principles of state policy. Now, what is this directive principles of state policy? To put it in a very simple way, these are directives which are given in the Constitution to the state. Or in other words, these are directions which are given in the Constitution to the organs of the state, like the legislature and the executive, as to what they are supposed to do. And if they do all these things, or if they follow all these directives which is given in the Constitution, then that would automatically lead to the welfare of the people. And that is why these directives are given in the Constitution. And where these directives are mentioned? These directives are mentioned in the part 4 of the Constitution. Right from Article 36 to Article 51 is where these directives are mentioned. In fact, for our own understanding, although this distinction is not there in the Constitution, for our own understanding, these directives are classified into socialistic principles, Gandhian principles, and liberal intellectual principles. Socialistic principles are those directives which is related to the concept of welfare of everyone in the society, promoting equal wealth, allowing the participation of workers in the management. So equal justice or free legal aid to the poor people. So basically it is involved in the social justice to the people. And there are certain principles which are also Gandhian in nature. Now these are all principles which basically wanted to give effect to the ideologies of Gandhiji. Say for example, prevention of intoxicating drinks, for example, promotion of rural economy, cottage industries, uh, promotion of panchayat system. So these are all basically the ideas of Gandhiji, and these directives are called as Gandhian principles. And then you have something which is called as liberal intellectual principles. And what are these liberal intellectual principles? The liberal intellectual principles are those principles that which is far ahead of a time, or which is very liberal in nature. Say for example, protecting the environment, protecting the monuments of national interest, and then of course to amicably settle the dispute between the foreign nations. So these are all some of the principles which are so liberal and so advanced in their thoughts, and such type of principles are what is called as liberal intellectual principles. But again I am repeating it that these things are not classified in the constitution. It is only for our own understanding we have classified this. Now again coming back to the directive principles of state policy, what did we learn? These are nothing but the directives which are given to the state. That is for the government to do all those things. That is for the legislature to make laws and probably implement these directives. It has got nothing to do with the citizens. But however, try to understand, is it mandatory for the state to implement all those things? Is it mandatory for the government to implement all those things? It is not at all mandatory. So similar to that of the fundamental duties, which is only a moral obligation upon the citizen. Here, the directive principles of state policy is only a moral obligation upon the state. That means if the state is not implementing any of these directives, then we as a citizen cannot enforce it in a court of law. So what is the similarity between the fundamental duties and directive principles of state policy? Both are moral obligation. Fundamental duty, moral obligation for the citizens, but whereas directive principles of state policy, moral obligation for the state. Whereas fundamental rights are legally enforceable. Whenever it is violated, the affected citizens can approach the court, both the Supreme Court and High Court. So that's basically what you'll have to understand. I'm sure that till this point of time, it should be very clear. In fact, this directive principles of state policy is not something very new. The directive principles of state policy was already there in one or the other form. It was there in the Government of India Act 1935. It is also called as the instrument of instruction at that point of time. So if at all a question comes, this instrument of instruction in the Government of India Act 1935 is related to what in present constitution is nothing but it is related to the directive principles of state policy. And if a question comes, the objectives resolution introduced in the Constituent Assembly is similar to that of what? The objectives resolution is similar to that of what is called as the preamble in the present constitution. So these are the questions sometimes asked in the examination. And now the next thing is a secular state. Okay, before going to the secular state, why do you think that the directive principles of state policy was made merely as a moral obligation? Because Dr. B.R. Ambedkar thought that making it a legal obligation would lead to unnecessary litigation in a court of law. And these directives which is given in the constitution are so idealistic, the state does not have the resource to implement all those things. So as and when there is a resource, let the state implement these things gradually one by one. Until that point of time, let it continue to be what is called as a moral obligation. It is for them to implement as and when they wanted to implement. But at the same time, Dr. B.R. Ambedkar was convinced in a democracy, in an electoral democracy, no government of the day can keep ignoring these directives for a long period of time. If they keep ignoring these directives for a long period of time, then the people will automatically vote this government out of power when the next election comes, because we also have a system of what is called as periodic election. So Dr. B.R. Ambedkar was convinced that even though it is a moral obligation, no government of the day can keep ignoring these directives for a long period of time, and for their own interest they have to implement that if they have to win the elections. So he thought that let it continue to be what is called as a moral obligation. And then the next concept is what is called a secular state. Now, what do you mean by secular state? The concept is very simple. I'll give a broader explanation when I take up the topic of preamble, but for time being, what is a secular state? Secular state means a state does not officially recognize itself with any religion, or the state has no official religion. Say, for example, India as a state, it has no official religion. But on the contrary, it recognizes all the religion. It respects all the religion. And it maintains equal distance from all the religion. It shows equal respect towards all the religion. So that's basically what is called as the idea of secularism. So what is a secular state? A secular state is something that it does not identify itself with any religion, or it does not officially have any religion, but it does respect all the religion equally. So this is basically the primary concept of what is called as secularism. Or in other words, the state will not have any policies in a way that it will discriminate people on the basis of religion, because all religions are equal to the state, and the state has nothing to do with favoring one religion or another religion. That's primarily what is called as a secular state, or the idea of secularism. But however, before I move to the next topic, the kind of secularism in India is also what is called as positive secularism. On the contrary, the secularism in the Western countries is what is called as negative secularism. Say, for example, USA is also a secular state. India is also a secular state. But in USA, it is called as Western secularism or negative secularism, whereas in India, it is called as positive secularism. So if you know any difference between these two secularism, you can put the answers in the comment box. But for time being, I am not discussing it because I want to discuss this elaborately when I take up the preamble to the Constitution of India, not at this stage because it's a very basic class. So let I move forward one step at a time. But if you know any differences between the positive and the negative concept of secularism, you can put it in the comment box. Come to the next thing, that is universal adult suffrage. What do you understand by universal adult suffrage? That all eligible adult individuals shall have the right to vote. Today, under the Constitution, do we have universal adult suffrage? Yes. When was a system of direct election introduced when the Britishers ruled India? 1919, and it was carried forward in 1935 also. But at that point of time, there was limited adult suffrage. Limited adult suffrage means discriminatory between people. Some of them are given the voting rights, others are not giving the voting rights, which does not basically go with the idea of what is called as equality under the Constitution of India. So this limited adult suffrage was done away with, and the Constitution has brought in what is called as universal adult suffrage. The Constitution today gives voting rights to all the people, irrespective of their race, religion, caste, sex, whatever be it, they shall not be discriminated. And all adult individuals, eligible adult individuals, shall be given the right to vote. Or in other words, we follow the principle of what is called as one man, one vote, one value when it comes to election to the Lok Sabha and the legislative assemblies. And thereby we are also following the principle of what is called as universal adult suffrage. So these are all the important features that you should have an idea. So before I wind up the class, just few more features, very important features. So let us move to the next thing, that is basically what is called as single citizenship. Now what do you mean by single citizenship? Now single citizenship means under the Constitution that we will be eligible to have only one citizenship, that is only citizenship of India. So does it mean that we will not be able to have a citizenship of another country? Yes. When we are having the citizenship of India, we will not be able to have the citizenship of another country. That doesn't mean that you cannot take up the citizenship of another country. Yes, we are free to take up the citizenship of another country as a free man out of our free will. But if you take up the citizenship of another country, our Indian citizenship will get terminated. So at a time, you may be able to have only one citizenship. There are some countries that allows for multiple citizenship, but the Indian Constitution does not allow for it. So when I talk of single citizenship, we'll have to understand two things. One is that we will not be able to have a citizenship of another country when we are a citizen of India. And if you take up the citizenship of another country, then our Indian citizenship will get terminated. Is it possible for us to have a citizenship of India and a citizenship of a particular state in India, say for example state of Karnataka, say for example state of Madhya Pradesh, say for example state of Punjab, and also simultaneously having a citizenship of India? That is also not possible. All that is provided under the constitution is only the citizenship for the entire country. The constitution does not provide for the citizenship for each and every state. And basically this was followed by the Constituent Assembly in order to ensure what is called as the unity and integrity of India, and to promote the feeling of fraternity, that is the brotherhood among the people. So if different states are to give their own citizenship, the Constituent Assembly feared that that would affect the unity and integrity of the nation. That would create a sub-national identity within India, which they were not interested in. So that is why we have a concept of what is called as single citizenship. And then under the constitution, we also have what is called as independent bodies. That's again very important. Or in other words, independent constitutional authorities. When I was discussing about the concept of separation of powers, I spoke about three important authorities under the constitution: the legislature, the executive, and judiciary. And they are supposed to perform certain functions which is entrusted upon them by the constitution. So do we have only these three authorities, or do we have any of the other authorities apart from this? Yes. Apart from these three major authorities, we also have a lot of independent constitutional bodies. And who are those independent constitutional bodies? Say for example, today we have an independent constitutional body, what is called as the Election Commission of India, under Article 324, which is to ensure what is called as the free and fair election. Under the Constitution of India, we have an independent constitutional body which is called as a Union Public Service Commission. In fact, students appearing for UPSC examination, their examination is conducted by Union Public Service Commission, which is established under Article 315 of the Constitution. Independent Finance Commission, which is to recommend how the finance is to be distributed between the center and the states, Article 280. And then we have an independent constitutional authority which is called as a Comptroller and Auditor General under Article 148, who is to audit the revenues of the government of India and also of the states. So in this way, we have other independent constitutional authorities also, but this is to name a few, like the Election Commission, CAG, and all those things. So they do have their unique function, ensuring the smooth functioning of the entire country. So that is what is called as independent bodies or independent constitutional authorities. Don't worry about this independent constitutional authorities. My explanation to that is not elaborate, because this is not the time to deal with all those things, which I'll discuss in the later part. But you should know what is an independent body. An independent body is free from the control of the other organs of the state. So for example, the Election Commission of India is an independent constitutional body, which means it cannot be controlled by the legislature, it cannot be controlled by the executives, and the judiciary also normally does not interfere with the functioning of the independent constitutional authorities, because they are deriving independently the powers from the constitution itself. They are independently established by the constitution itself, and that's why they are called as independent bodies. And then the constitution also provides for what is called as emergency provisions. Now what is this emergency provisions? To just try to have an understanding that these are provisions in the constitution which normally will remain dormant. Dormant means that these provisions will not be used like the other provisions which are active. Or you can say that the other rules which are used often, these rules may not be used unless and until a situation arises. Unless and until an emergency situation arises. So this is the vision that our founding fathers had, that not every time that the country will be in a normal situation. There might be a possibility that there is an emergency situation or an extraordinary situation that may arise. Under such a situation, you will have to go for a change in the rules. And because extraordinary situation requires extraordinary measures. So the constitution should go for a transformation to meet an emergency situation. So under such a situation, these emergency provisions can be invoked and it can be used. And that's basically what is called as the emergency provisions. That means for time being, you understand that these emergency provisions are not often used. These rules remain dormant in the constitution unless and until an emergency situation arises. And when the emergency situation arises, these provisions can be used. And when the emergency provisions arises, then the constitution goes for a change in the way that they function because of the emergency provisions in the constitution. And the Constitution of India recognizes three types of emergencies. And what are those types of emergencies? The first type of emergency is what is called as a national emergency. The second type of emergency is what is called as state emergency. And the third type of emergency is what is called as financial emergency. Now, what these emergencies are, we'll discuss that in detail when I take up the emergency topic at the later stage. But right now, try to understand as to what these emergencies or what are these emergency provisions, when they may be used only during extraordinary circumstances. So, before I go to the next topic, now one question to all the students: of all the three emergencies that I told, national emergency, state emergency and the financial emergency, one type of emergency has never been used in our country. Since 1950 till this point of time, one particular emergency has never been invoked by the President of India. And what type of emergency is that? Is it national emergency, or is it state emergency, or is it what is called as the financial emergency? Remember, the state emergency is also called as a president rule. So you can put your probably answers in the comment box. Come to the next provision, rigidity and flexibility, which is again a feature of the Indian Constitution, which means, which I have already discussed as a feature of the Indian Constitution, that the Constitution of India is an organic document. This Constitution can go for a change and it can be amended, and this power is given to the Parliament under Article 368. So, is it difficult to amend the Constitution or is it easy to amend the Constitution? And the answer is, some provisions are easy, but most of the provisions are difficult under Article 368, and hence we call that it is a blend of flexibility and rigidity, or rigidity and flexibility. And then the last thing is written constitution, which you have already seen, that the Constitution of India is basically written or codified into a single document. And apart from the Constitution of India, there can be other rules by the ordinary laws, but they are not part of the Constitution. A written constitution which distinguishes itself into what is called as a constitutional law and ordinary law. So, India is the lengthiest known written constitution in the world, and that is again an important feature of the Indian Constitution. So, this class, I would say, it's very important for the students, and if you watch this particular video, try to watch it completely if you are a serious candidate preparing for the civil service examination or for the public state public service examination. It will be of immense benefit to all the candidates who are watching it. So, you have seen a list of features. Again, I wanted to make this very clear to all the students. The idea of this particular lecture is to give a basic idea. You cannot have an in-depth idea in the very starting lectures itself. But as and when I proceed, I will discuss some of these topics again in length and in detail, because then you will be in a position to observe most of the things that I discuss. But right now it is to give a basic idea about the features. But however, even in this particular lecture, you will be easily able to answer one or two questions that will come in the examination. Alright. So, with that, I will just go to the question that I wanted you to solve. So, look into this particular question, and if you listen my lecture, it would be easy for you to answer this particular question. A parliamentary system of government is one which A, all political parties in the parliament are represented in the government. That is option A. Option B, the government is responsible to the parliament and can be removed by it. Or in other words, it is saying that the government is accountable to the parliament. C, the government is elected by the people and can be removed by them. So, just think about it. In a parliamentary democracy, can the government elected by the people and can they also be removed by the people? So, that is a question. Option D, the government is chosen by the parliament but cannot be removed by it before the completion of a fixed term. That means, in other words, in a parliamentary democracy, is it always that once a government is elected, it will complete its fixed term? So, these are all the options that is given. So, what exactly reflects the idea of what is called as parliamentary democracy? You can put your answers in the comment box, and if you have any queries from the lecture, you can reach out to me through my Instagram account or through my Telegram channel, and this is the ID for both my Instagram as well as my Telegram channel. And if you have any of your friends or family members preparing for any competitive examination, including the UPSC examination, you can refer this channel to all of them. And I'm quite sure that the videos in the YouTube channel would be immensely beneficial to all the students. Thank you very much. All the very best.